Glock just got by California. Yeah, I said it.
Gun rights groups have filed a lawsuit challenging California's ban on Glock-style weapons.
The biggest handgun company on the planet just got told to sit down, shut up, and redesign 80% of their lineup.
July 1st, 2026. That's the date when the most popular handgun in America becomes contraband in the nation's most populous state. Not through a typical gun ban, not by outlawing dangerous weapons, but by legally redefining what a Glock is. California Governor Gavin Newsom signed Assembly Bill 1127, the Responsible Gun Manufacturing Act, into law on October 13th. On paper, it sounds reasonable. In practice, it reclassifies one of the world's most common firearms as something else entirely. A Glock is no longer just a handgun. According to California law, it's now a machine gun convertible pistol. And starting next July, all sales of these newly categorized weapons will be banned statewide. Here's where the story gets interesting and complicated and potentially precedent-shattering. The law's logic rests on a simple premise. A Glock can be transformed into an automatic weapon using a screwdriver and a pistol converter device. The bill's text is specific about this. It defines a machine gun convertible pistol as any semi-automatic pistol with a cruciform trigger bar that can be readily converted by hand or with common household tools into a machine gun by installing a pistol converter. The law then defines what a pistol converter actually is. Any device that, when installed in or attached to the rear of a semi-automatic pistol's slide, replaces the back plate, interferes with the trigger mechanism, and enables automatic fire, more than one shot per trigger pull. Therefore, California reasons firearms dealers cannot sell, buy, give, or transfer Glocks because these weapons now fall under the machine gun convertible category. The ban doesn't just restrict new purchases, it criminalizes the entire commercial ecosystem around these firearms. But here's the twist that makes this legislation particularly strange. Glock switches, the conversion devices the law describes, have been illegal since 1986. The Federal Firearm Owners Protection Act prohibited civilians from owning new machine guns or conversion kits after that year. These modifications have always fallen into the illegal conversion kit category. They've been banned in California for nearly 4 decades. So California isn't banning something new. They're banning the gun itself because of what someone could illegally do to it. This law is going to collide with recent Supreme Court precedent like a freight train hitting a brick wall. 2 decisions in particular create massive legal obstacles for California's ban. The first landmark case came in 2008, District of Columbia versus Heller. Washington, D.C. had issued sweeping anti-gun regulations, including a requirement that gun owners receive a license from the chief of police. Licenses that expired annually and required constant renewal. A man named Richard Heller was denied a license and sued. The case reached the Supreme Court, which faced a fundamental question. Does the Second Amendment protect an individual's right to keep and bear arms, or only a militia's right? After 3 months of deliberation, the court's majority ruled definitively. The Second Amendment protects individual gun ownership. The decision's language was unambiguous. The term militia shouldn't be confined to those serving in the military. At the time of writing, it referred to all able-bodied men capable of being called to service. Reading the amendment as limiting arms to governed military forces would create exactly the state-sponsored force the amendment was meant to protect against. The court concluded that banning an entire class of commonly used firearms for protection, like handguns, and prohibiting functional firearms in the home violates the Second Amendment. This precedent alone creates serious problems for California's Glock ban. The second critical precedent came in 2022, New York State Rifle and Pistol Association versus Bruen. New York had required citizens to demonstrate proper cause for concealed carry permits, essentially proving they faced special danger beyond ordinary citizens. This requirement had been in place for 111 years. The Supreme Court ruled against New York, but the real significance was how Justice Clarence Thomas framed the decision in his majority opinion. He wrote that the burden falls on defendants, meaning the government, to show that restrictive gun laws are consistent with the nation's historical tradition of firearm regulation. Constitutional rights are enshrined with the scope they were understood to have when the people adopted them. This established a new and much more stringent legal test. Governments must prove their restrictive gun laws align with historical tradition. It doesn't matter that something was done a certain way for over a century. What matters is whether it's consistent with how the Second Amendment was conceived when written. This precedent essentially requires states to justify gun restrictions against 18th century standards of what the founders intended. It's an extraordinarily high bar, and one that California's Glock ban will struggle to clear. Now let's talk about why the Glock specifically presents such a problem for California's legal theory. This isn't some rare, specialized firearm. It's arguably the most popular handgun in existence. According to official company statements from 2023, Glock has produced over 20 million units. According to law enforcement today, Roughly 65% of U.S. police departments use Glocks as their standard issue handgun. Even former Vice President Kamala Harris, a California resident, chose a Glock as her personal firearm. During the campaign trail, she mentioned it on Oprah's show, stating matter-of-factly that she owns a Glock and has for quite some time. The weapon is clearly in common use, and Supreme Court precedent has repeatedly emphasized that common use matters enormously for Second Amendment analysis. In 2015, Justice Clarence Thomas wrote a dissenting opinion when an Illinois government tried to ban semi-automatic rifles like the AR-15. The state argued these weren't in common use when the Second Amendment was ratified. Thomas rejected this reasoning entirely. He wrote that several courts of appeals had upheld categorical bans on firearms that millions of Americans commonly own for lawful purposes, calling such rulings non-compliant with Second Amendment precedent. He continued, such rulings suggested states could ban AR-style rifles, even though an overwhelming majority of citizens who own them do so for lawful purposes, including self-defense and target shooting. Under Supreme Court precedent, lawful common use is all that's needed for citizens to have a Second Amendment right to keep such weapons. If that logic applies to AR-15s, it almost certainly applies to Glocks, which are far more common and widely used by both civilians and law enforcement. California's ban will take effect July 1st, 2026. From that moment, the Glock, now classified as a machine gun convertible pistol, cannot be legally sold in the state. But everyone watching this legal drama knows what happens next. Someone will sue. The case will wind through district courts, appeals courts, and potentially reach the Supreme Court within 1 or 2 years. Given current precedent from Heller and Bruen, California faces an uphill battle defending this legislation. The state will need to prove that banning Glocks aligns with historical tradition of firearm regulation. They'll need to explain why a weapon in common use, owned by millions, carried by most police departments chosen by a former vice president, should be categorized as a machine gun based on what someone could illegally do to modify it with already banned parts. That's a tough argument to make, especially before a Supreme Court that has consistently expanded Second Amendment protections over the past 15 years. This law represents California's latest move in a decade-long campaign of increasingly restrictive gun legislation. While over half of U.S. states have gone constitutional on Second Amendment issues, enshrining gun rights in state constitutions and statutes, California has moved aggressively in the opposite direction, passing one restriction after another. The Glock ban may be the most ambitious attempt yet. If it survives legal challenges, it opens the door to banning virtually any firearm that could theoretically be modified with illegal parts. If it fails, which seems more likely given Supreme Court precedent, it may finally establish clear boundaries on how far states can push gun restrictions under the guise of public safety. Either way, July 1st, 2026 marks a pivotal moment. The most popular handgun in America becomes illegal in the nation's largest state, at least temporarily. What happens next will shape gun rights across the entire country for years to come.